Obligations and Contracts Title 1. Obligations Chapter 3. Different kinds of obligations Section 1. Pure and conditional obligations Article 1179. Every obligation whose performance does not depend upon a future or uncertain event, or upon a past event unknown to the parties, is demandable at once. Every obligation which contains a resolutory condition shall also be demandable, without prejudice to the effects of the happening of the event. Pure obligation and unqualified obligation which is demandable immediately. Its performance does not depend upon a future and uncertain event, or upon a past event unknown to the parties. Conditional obligation, the reverse of a pure obligation. Its performance depends upon a future and uncertain event or upon a past event unknown to the parties, and its efficacy or obligatory force is subordinated by the happening of the future and uncertain event. Condition. A condition is an act or event, other than a lapse of time, which, unless the condition is excused, must occur before a duty to perform a promise in the agreement arises or which discharges a duty of performance that has already arisen. Resolutory condition versus suspensive condition. Resolutory condition extinguishes the obligation once the future and uncertain event happens, whereas suspensive condition gives rise to the obligation upon the happening of a future and unknown event or a past event unknown to the parties. Resolutory condition is demandable at once, whereas suspensive condition is demandable only at the time the event happens. Resolutory condition is a condition subsequent, e.g., in reciprocal obligations, the obligation of one is a resolutory condition of the obligation of the other, while suspensive condition is a condition precedent, e.g., contract to sell, sale upon completion of payment, and contract of sale, perfection of sale upon completion of payment. Article 1180. When the debtor binds himself to pay when his means permit him to do so, the obligation shall be deemed to be one with a period, subject to the provisions of Article 1197. This is one of the cases when the court assigns a period within which the payment is to be made, especially when the period depends upon the will of the debtor, when his means permit him to do so in this article. Article 1181. In conditional obligations, the acquisition of rights, as well as the extinguishment or loss of those already acquired, shall depend upon the happening of the event which constitutes the condition. Article 1182. When the fulfillment of the condition depends upon the sole will of the debtor, the conditional obligation shall be void. If it depends upon chance or upon the will of a third person, the obligation shall take effect in conformity with the provisions of this code. Suspensive potestative condition. A condition whose fulfillment depends upon the sole will of the debtor. Absolute rule. A suspensive potestative condition is always void. It is the obligation accompanying the condition which may be a void, if the suspensive potestative condition is imposed on the birth of the obligation. This is now called a suspensive condition. Facultative as to the debtor, be valid, if the suspensive potestative condition is imposed merely on the fulfillment of the obligation. In this case, the parties must go to court to have the period fixed. Article 1183. Impossible conditions, those contrary to good customs or public policy and those prohibited by law, shall annul the obligation which depends upon them. If the obligation is divisible, that part thereof which is not affected by the impossible or unlawful condition shall be valid. The condition not to do an impossible thing shall be considered as not having been agreed upon. Impossible conditions. General rule. An obligation with an impossible condition is void. In addition, the condition to do an impossible thing is deemed not agreed upon, and is thus not part of the contract. Exception. If the obligation is divisible, the part thereof not affected by the impossible condition is still valid. Article 1184. The condition that some event happen at a determinate time shall extinguish the obligation as soon as the time expires or if it has become indubitable that the event will not take place. Article 1185. The condition that some event will not happen at a determinate time shall render the obligation effective from the moment the time indicated has elapsed, or if it has become evident that the event cannot occur. If no time has been fixed, the condition shall be deemed fulfilled at such time as may have probably been contemplated, bearing in mind the nature of the obligation. Condition that an event will happen at a determinate time. Two effects. 1. Will extinguish the obligation as soon as the time expires, or 2. Will extinguish the obligation if it has become unquestionable that the event will not happen. Condition that an event will not happen at a determinate time. Two effects. 1. Shall render the obligation effective from the moment the time indicated has elapsed. 2. Shall render the obligation effective if it has become evident that the event will not occur if no time has been fixed. The time as may have been probably contemplated will be considered. Article 1186. The condition shall be deemed fulfilled when the obligor voluntarily prevents its fulfillment. Constructive fulfillment of the obligor voluntarily prevents the fulfillment of a condition in an obligation. The law states that the obligation shall be fulfilled. Also called the doctrine of prevention basis, good faith in both of the parties should not impede, hinder, or obstruct or prevent the fulfillment of the obligation. Article 1187. The effects of a conditional obligation to give, once the condition has been fulfilled, shall retroact to the day of the constitution of the obligation. Nevertheless, when the obligation imposes reciprocal prestations upon the parties, the fruits and interests during the pendency of the condition shall be deemed to have been mutually compensated. If the obligation is unilateral, the debtor shall appropriate the fruits and interests received, unless from the nature and circumstances of the obligation it should be inferred that the intention of the person constituting the same was different. In obligations to do and not to do, the courts shall determine, in each case, the retroactive effect of the condition that has been complied with. Retroactive application of obligations. General rule. An obligation is deemed to have been fulfilled not on the day of its fulfillment, but the day of the constitution of the obligation. Only applicable to obligations with suspensive conditions. Application. 1. In reciprocal obligations, the fruits and interests of the object during the pendency of the condition cancel each other out. 2. In unilateral obligations, the fruits and interests of the object during the pendency of the obligation belong to the obligor, unless the circumstances or the intention of the person constituting the obligation says otherwise. Article 1188. The creditor may, before the fulfillment of the condition, bring the appropriate actions for the preservation of his right. The debtor may recover what during the same time he has paid by mistake in case of a suspensive condition. Protective measures before the fulfillment of an obligation for the creditor, bring appropriate actions, e.g., an injunction suit to stop the debtor from alienating a property which is the object of an obligation. To protect his or her right for the debtor, recover what he or she has paid by mistake before the fulfillment of a condition in an obligation. Article 1189. When the conditions have been imposed with the intention of suspending the efficacy of an obligation to give, the following rules shall be observed in case of the improvement, loss or deterioration of the thing during the pendency of the condition. 1. If the thing is lost without the fault of the debtor, the obligation shall be extinguished. 2. If the thing is lost through the fault of the debtor, he shall be obliged to pay damages. It is understood that the thing is lost when it perishes, or goes out of commerce, or disappears in such a way that its existence is unknown or it cannot be recovered. 3. When the thing deteriorates without the fault of the debtor, the impairment is to be borne by the creditor. 4. If it deteriorates through the fault of the debtor, the creditor may choose between the rescission of the obligation and its fulfillment, with indemnity for damages in either case. 5. If the thing is improved by its nature, or by time, the improvement shall inure to the benefit of the creditor. 6. If it is improved at the expense of the debtor, he shall have no other right than that granted to the usufructuary. Scenarios during the pendency of an obligation. This article applies to those obligations with suspensive conditions. Choice of remedy always belongs to the creditor. Event loss. A. Without debtor's fault, obligation is extinguished. B. With debtor's fault, debtor to pay damage to deterioration. A. Without debtor's fault, impairment is borne by creditor. B. With debtor's fault. 1. Rescission of obligation plus damages. 2. Fulfillment of obligation plus damages. Improvement. A. With debtor's fault, by nature or time, shall inure to the benefit of creditor. B. With the debtor's fault, at the expense of debtor. Debtor shall only be a usufruct. Loss. A thing is deemed lost when it 1. Perishes. 2. Goes out of commerce. 3. Disappears in such a way that its existence is unknown or it cannot be recovered. A usufruct gives a right to enjoy the property of another with the obligation of preserving its form and substance unless the title constituting it or the law provides. Article 1190. When the conditions have for their purpose the extinguishment of an obligation to give, the parties, upon the fulfillment of said conditions, shall return to each other what they have received. In case of the loss, deterioration or improvement of the thing, the provisions which, with respect to the debtor, are laid down in the preceding article shall be applied to the party who is bound to return. Note: this article applies to obligations with resolutory conditions. Same scenarios as in Article 1198. Article 1191. The power to rescind obligations is implied in reciprocal ones, in case one of the obligors should not comply with what is incumbent upon him. The injured party may choose between the fulfillment and the rescission of the obligation, with the payment of damages in either case. He may also seek rescission, even after he has chosen fulfillment, if the latter should become impossible. The court shall decree the rescission claimed, unless there be just cause authorizing the fixing of a period. This is understood to be without prejudice to the rights of third persons who have acquired the thing, in accordance with Articles 1385 and 1388 and the Mortgage Law. Notes: power to rescind does not merely mean to terminate a contract and release the parties from further obligations to each other, but more importantly, it means to abrogate the contract from the beginning and restore the parties to their original positions as if no contract has been made. Requires a substantial breach of an obligation. Substantial is to defeat the object of the parties in entering into an agreement. Implied rescission versus express rescission. Enforcement. In implied rescission, enforcement is through court action, while in express rescission, enforcement is through a stipulation in the contract that the violation of its terms shall cause the cancellation, termination, or rescission thereof without court intervention. Purpose of court action. In implied rescission, purpose of court action is to enforce rescission, while in express rescission, the purpose of a court action is to judge whether the rescission is proper. Final judgment of court shall only confirm such rescission. Revocatory act. In implied rescission, revocatory act is a final judgment of the court. Court shall fix a period, however, if there is a just cause. While in an express rescission, revocatory act is a notice to the defaulter of such rescission. Notes: injured party who suffers a substantial breach has the following choices. 1. Fulfillment of obligation plus damages. 2. Rescission of obligation plus damages. 3. Rescission, even after the injured party has chosen fulfillment, if fulfillment should become impossible plus damages. Article 1192. In case both parties have committed a breach of the obligation, the liability of the first infractor shall be equitably tempered by the courts. If it cannot be determined which of the parties first violated the contract, the same shall be deemed extinguished, and each shall bear his own damages. Notes: in pari delicto, if first violator is determined, such first violator is liable, but his liability will be tempered because the other party is also at fault. If first violator cannot be determined, obligation shall be deemed extinguished, and each shall bear his her own damages. Section 2. Obligations with a period. Article 1193. Obligations for whose fulfillment a day certain has been fixed shall be demandable only when that day comes. Obligations with the resolutory period take effect at once, but terminate upon arrival of the day certain. A day certain is understood to be that which must necessarily come, although it may not be known when. If the uncertainty consists in whether the day will come or not, the obligation is conditional, and it shall be regulated by the rules of the preceding section. Notes: period designates a particular time which is certain to happen as the moment when the obligation will either be effective or be extinguished. A day certain is understood to be that which must necessarily come, although it may not be known when. When the day may not necessarily come, it is a condition 1. Suspensive period gives rise to the effectivity of the obligation 2. Resolutory period extinguishes the obligation. Article 1194. In case of loss, deterioration or improvement of the thing before the arrival of the day certain, the rules in Article 1189 shall be observed. Article 1195. Anything paid or delivered before the arrival of the period, the obligor being unaware of the period or believing that the obligation has become due and demandable, may be recovered, with the fruits and interests. Notes: payment before period comes, if the debtor is unaware of the period, he or she may recover the thing with fruits and interests only during the time he or she was not obligated to give the thing. If the debtor and creditor have full knowledge of the period, no problems. Obligation is fulfilled. Why does the law use fruits and interests? The preceding term is paid or delivered. Fruits refer to delivered and interests refer to paid. Why does the law include fruits and interests in a case for damages? The obligor has lost the opportunity to make productive use of the money, so the law compensates for that. Article 1196. Whenever in an obligation a period is designated, it is presumed to have been established for the benefit of both the creditor and the debtor, unless from the tenor of the same or other circumstances it should appear that the period has been established in favor of one or of the other. Notes: benefit of the period. General rule: the period is always deemed to be established for the benefit of both the creditor and debtor. In reciprocal obligations, for example, either party does not incur in delay unless the other starts the fulfillment of his part during the period stipulated. Designations of creditor and obligor are irrelevant. Exception: the benefit of the period may be waived expressly or impliedly by the party in whose favor it was constituted. Article 1197. If the obligation does not fix a period, but from its nature and the circumstances it can be inferred that a period was intended, the courts may fix the duration thereof. The courts shall also fix the duration of the period when it depends upon the will of the debtor. In every case, The courts shall determine such period as may under the circumstances have been probably contemplated by the parties. Once fixed by the courts, the period cannot be changed by them. Notes: when courts shall fix the period, two-step process. 1. Court must determine whether the obligation does not fix the period, e.g., depends on the will of the debtor, and from the circumstances and nature of the obligation, a period was intended by the parties. 2. Court must determine the period contemplated by the parties. The court cannot fix a period based on its opinion. This period determined by the court is final and cannot be changed by anyone again. Article 1198. The debtor shall lose every right to make use of the period. 1. When after the obligation has been contracted, he becomes insolvent, unless he gives a guarantee or security for the debt. 2. When he does not furnish to the creditor the guarantees or securities which he has promised. 3. When by his own acts he has impaired said guarantees or securities after their establishment, and when through a fortuitous event they disappear, unless he immediately gives new ones equally satisfactory. 4. When the debtor violates any undertaking, in consideration of which the creditor agreed to the period. 5. When the debtor attempts to abscond. Notes: loss of the right to a period. Article 1198 applies to both reciprocal and unilateral obligations and those where the period is for the benefit of both parties or one party. Insolvency. Insolvency is defined as the inability to pay, and not necessarily the loss of property. Need not be judicially declared. General rule: period is lost, but the obligation does not become demandable upon insolvency. Exception: if the party can give securities or guarantees, the period is restored. Since the law gives an option for the party to furnish guarantees, the obligation is not immediately demandable in case of insolvency. Failure to furnish securities guarantees. In this case, the obligation is immediately demandable, as distinguished from the first case. Securities can take the form of mortgages or real estate pledges. If the guarantor has committed him herself solidarily to the obligation, the creditor can opt to go against the guarantor immediately without even going to the principal. Impairment. Loss of guarantees. Impairment does not mean destruction, but merely a diminishing of the guarantee. General rule: 1. If by his/her own acts, the party impairs the guarantee, he/she loses the right to a period. 2. If through a fortuitous event, the guarantee is impaired, the right to a period is lost. 2. Exception: in both cases, the period will be restored if the party gives new guarantees equally satisfactory. Violation of any consideration to a period. Because the consideration is the reason why the period was agreed upon, any violation of the consideration results to the loss of the right to the period, and the obligation becomes immediately demandable. The consideration is not a resolutory condition. A resolutory condition extinguishes the obligation. The consideration here hastens the extinguishment of the obligation. Attempt to abscond. To abscond means to physically flee, and not merely a failure to respond to the creditor's demands. Mere attempt make the obligation immediately demandable, because if the party succeeds in absconding, the creditor may never collect. Section 3. Alternative obligations. Article 1199. A person alternatively bound by different prestations shall completely perform one of them. The creditor cannot be compelled to receive part of one and part of the other undertaking. Notes: different prestations: to give, to do, and not to do, as contemplated in this article, refers to both the loose and strict sense of the protestation, but to be less confused, treat each object of the prestation individually. As a rule, rules in alternative obligations: complete performance of one of the alternatives, unless the creditor accepts partial performance if all but one of the alternatives shall become impossible. The obligation ceases to be alternative. Article 1200. The right of choice belongs to the debtor, unless it has been expressly granted to the creditor. The debtor shall have no right to choose those prestations which are impossible, unlawful, or which could not have been the object of the obligation. Article 1201. The choice shall produce no effect except from the time it has been communicated.